afternoon. Welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy and I'm a marketing manager here at Bond. Just two quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to answer those as time permits. Once the webinar has ended, we would appreciate it if you would take a moment to complete the survey. Your comments and suggestions for future topics are important to our panelists, and we do share those with everyone. So to start us off, it's my pleasure to introduce you to today's moderator, Adam Mastrolio.
Kathy, thank you so much, and thank you to everybody who is joining us this afternoon. We have another jam-packed program, a lot of updates in the COVID realm, but also in the general HR realm as well. And we're going to be putting some of these segments into our webinars from now on, and we hope you find them useful. But starting off today is DJ Nugent. DJ is an attorney in our employee benefits practice. DJ is going to talk to us regarding updates about dealing with the ARPA COBRA tax credit. So DJ, please take it away.
Thanks so much, Adam. Next slide, please, Kathy. So today, what I'm going to talk about, and we've talked about the ARPA COBRA subsidy in a variety of instances on some different topics. But today, what I want to talk about is employers and some other entities actually claiming the tax credit that's part of the ARPA COBRA subsidy. So just as a very brief overview, the ARPA COBRA subsidy was part of the American Rescue Plan Act of 2021 that was signed into law in March of this year. During the period of April 1 of this year through September 30th of this year, if you're an assistance eligible individual, you are entitled to a 100% subsidy for monthly COBRA costs. To be an assistance eligible individual, you need to meet a few requirements, some of which are you suffer a COBRA qualifying event that's either an involuntary termination of employment or a reduction in hours. You have to be eligible for COBRA during the subsidy period, and you must elect COBRA. A couple other requirements can come into play as well. If you meet the requirements to be an assistance eligible individual during the time frame above, you do not have to pay any amounts for COBRA. Your employer essentially is in the shoes of advancing that amount to the insurer or COBRA administrator on your behalf. And then the employer receives a tax credit against the Medicare payroll taxes as reimbursements for any amounts that were advanced. Next slide, please, Kathy. So that subsidy that the employers advance, again, is reimbursed against a credit against the Medicare hospital insurance payroll tax, which is a 1.45% tax. Assistance eligible individuals receive a subsidy for the full cost of their COBRA premiums plus the 2% administrative fee. So generally, when someone is placed on COBRA, they're required to pay 100% of their COBRA premiums plus a 2% administrative fee. During the subsidy period, they don't have to pay any of that if they're an assistance eligible individual, and employers are allowed to be reimbursed for that full 102% that the assistance eligible individuals do not pay. The way that employers receive a credit for this is by claiming the credit and reporting the number of individuals receiving the COBRA premium assistance on the designated lines of their quarterly federal employment tax return, which is usually a Form 941. Why we're talking about this now is the second quarter Form 941, which is the first quarter that is applicable here because it covers April, May, and June, is due at the end of July. The third quarter Form 941, so July, August, September, that's due at the end of October or early November, November 1. So we know employers are getting ready to start claiming credits to be reimbursed for the subsidies that they've advanced on their employees' behalf, and it may be having some questions. And we want to let you know that there has been some guidance released by the IRS that may be able to help you with those questions as you're getting these returns put together. Next slide, please, Kathy. The first piece of guidance from the IRS is Notice 2021-24. This came out a little earlier this year, and this provides two pieces of helpful information. The first piece is that employers or other applicable entities who may receive the reimbursement who anticipate receiving the credit can reduce the deposit of federal employment taxes, including withheld taxes, that it otherwise would be required to deposit up to the amount of the anticipated credit that they're going to receive for reimbursement of the ARPA COBRA subsidy. 2021-24 also talks about employers may request in advance of the amount of the anticipated credit that exceeds the federal employment tax deposits that are available for reduction. So just to take a brief step back, the COBRA subsidy tax credit that employers are entitled to is refundable. So if it exceeds the Medicare tax, the employers can get a refund of the amount over that tax amount. This advance provision anticipates that the government knows that even though the government is on the hook for paying for the assistance eligible individual subsidy, that employers are put in the shoes of essentially advancing those amounts until they can be reimbursed. And because of those advances, could face a potential liquidity or cash shortage issue. And that's what this advance is meant to help address. So if employers are looking to try to find an advance of these amounts, filing that Form 7200 is the way to go. Next slide, please, Kathy. The other notice that's been issued is IRS Notice 2021-31. Very long question and answer format guidance issued by the IRS, touches on a variety of topics, not just addressing the tax credit, a lot of other topics as well, but it does have two sections that contains a variety of Q&As on the tax credit. The first is guidance regarding calculation of the premium assistance credit. An example that I think is helpful that the guidance provides is that the amount of the premium assistance credit that can be claimed depends on whether the employer subsidizes the COBRA premium costs for similarly situated covered employees who are not assistance eligible individuals. What this means is if an employer has individuals who are both assistance eligible individuals and non-assistance eligible individuals, and it's the employer's practice or they have an agreement that they're providing a subsidy for COBRA costs for a certain period of time to non-assistance eligible individuals, maybe people who voluntarily resigned, some other set of facts, that can impact the amount of the tax credit that employers are eligible to claim for the amounts that they front for the assistance eligible individuals. So there are some factors that come into play on calculating how much an employer is entitled to receive as the ARPA COBRA subsidy credit. So there is some guidance and provide some different scenarios on when that may come into play and what employers may need to take into consideration in trying to claim the credit. Second topic that Notice 2021-31 addresses regarding the credit is guidance regarding claiming the premium assistance credit. It talks about who is eligible to claim the credit. So I've used the employer. In some instances, it may be a multi-employer plan. It may be an insurer. There are some different scenarios where it may not necessarily be the employer who's in the shoes to file for the tax credit is reimbursement. So there is some guidance on who actually gets to claim it. Another area that this heading talks about is when does the premium payee, that's usually going to be the employer, become entitled to the premium assistance credit? And the guidance offers this example that I think is helpful. So on June 17 of this year, the employer receives a COBRA election form from a potential assistance eligible individual who elected COBRA continuation coverage retroactive to April 1, 2021. The employer is entitled to claim the credit as of that June 17 date. They're not entitled to claim it before that date. And that on June 17, they're entitled to claim the tax credit for premiums not paid by the assistance eligible individual for periods of coverage from April 1 through April 30, May 1 through May 31, and June 1 through June 30 in this scenario. That's going to be on the second quarter of Form 941 due at the end of July. If that assistance eligible individual receives COBRA premium assistance subsidies in July, August, September, those credits are going to be claimed on the third quarter tax return. One issue we've seen being discussed, there's not necessarily clear guidance, but we do think there is a good read based on the 941 instructions. Is as employers, they have 11 days to file their Form 941 to receive the tax credit for the second quarter. To be saying, we don't necessarily have everything that we need, all the information we need to claim a credit for the second quarter for the assistance eligible individuals who received the COBRA subsidy during that quarter. Can we claim a credit for those amounts in the third quarter? We think the answer to that is no. Don't claim a credit from the second quarter on the third quarter's Form 941. We think the way to handle that is to file an amended Form 941, which is that Form 941X, when you have all of the information necessary. So that's just an example of one area we've seen some discussion on. We know there's a lot of questions that employers have right now. The takeaway is it's getting close to the time to file these credits. File for these credits, and there is some guidance out there from the IRS. So if you have questions, hopefully that guidance will be able to help answer them. And that's all I have, Adam.
DJ, all I'll say is thank God there are people like you who like to look into these things. I was trying to think of a follow-up question for you, but I didn't really understand anything that you said, even though you laid it out very nicely and clearly. So if anybody has any questions about this COBRA tax credit, please contact DJ. You're in great hands. As you can see, he knows these topics and knows this stuff very well. So thank you, DJ. I appreciate you taking the time. Next, we're going to turn to an issue that was written about by one of our attorneys in the Albany office, Nila Sikander. Wrote a great blog piece for our labor and employment blog about dress code issues. And we thought that it was particularly timely because a lot of employers are starting to bring their employees back to the office more regularly, and these issues are going to start to crop up again. So Nila is going to talk to us about that this morning, or this afternoon, I should say. So thanks, Nila. Take it away.
Thanks, Adam. So I think when we talk about returning to work, there are a couple gentle reminders that you may have to provide your employees with. But I also wanted to talk a little bit about just hair discrimination in particular. Many of us spend a lot of time on our hair in the mornings while getting ready to work, and transitioning from kind of a home office environment to a work environment can be can require your employees to be gently reminded about your organization's dress code and grooming policies. But I wanted to talk a little bit about, just provide you a little bit of background around hair discrimination in the workplace and a couple of studies that had come out of recently in 2019. And there was a study provided, in collaboration with Dove and the Crown Coalition, and it was called a Crown Research Study. And it found that Black women are 1.5 times more likely to be sent home from the workplace because of their hair as you start, enforcing your dress code and grooming policies. And Black women's hair is 3.4 times likely to be perceived as unprofessional. And in that kind of environment, and based on this study, we've seen recently more focus on some of the certain legislative developments around this. Next slide, please. So on a federal level, in March 2021, Congress reintroduced in both the House and the Senate an act known as Creating a Respectful and Open World for Natural Hair Act, and that's the Crown Act. The Crown Act proposes to prohibit discrimination based on an individual's style or texture of hair, and including an individual's style of hair in the definition of racial discrimination. You will find that issues around hair discrimination have a close link to discrimination based on race, national origin, or religion. This definition that they're proposing includes hair that is tightly coiled or tightly curled, locks, twists, braids, afros, or any other style of hair commonly associated with a race or national origin. Next slide, please. And on a state level, state governments have passed their own versions of the Crown Act, from California to New Jersey to Washington to Connecticut. And there are similar bills that are pending in several states. I think at last count, it was about 17 or 18 bills that were pending. Next slide, please. And in New York, and New York City, you will find and you will recall that in 2019, the human rights law was amended to define race for certain specific purposes, not to be limited to ancestry, color, ethnic group identification, and ethnic background, and to include traits that are historically associated with race, which are not limited to hair texture and protective styles. New York City has kind of gone further, where they've issued a very comprehensive legal enforcement guide on race discrimination on the basis of hair. And you will find a lot of useful information from the historical kind of premise to why these protections are necessary. Next slide, please. So, as an employer, of course, you can impose requirements around maintaining a work kind of appropriate appearance. But if you are operating in an in an environment where a version of the Crown Act is in place, you cannot enforce such policies in a discriminatory manner or target specific hair textures or hairstyles. Grooming or appearance policies that generally target communities of color, religious minorities, or other protected communities could be considered discriminatory. So I guess the question is, what does this look like? I mean, how do we know what that looks like? And I thought I'd focus a little bit on a couple of examples that are based on legislative history or on cases. And I thought we could kind of look at some of those examples of what that really looks like. Next slide, please. So for instance, refusing to hire applicants or firing current employees for wearing their hair the way it naturally grows or in a protective hairstyle. So for instance, you're at the interview table and a candidate appears with their natural hair, and you decide that that's really not the appearance or the style that you want in your workplace, but you refuse to hire that applicant based on that specific characteristic, and you kind of verbalize that. Grooming policies that expressly prohibit hairstyles commonly associated with African Americans. So for instance, if your policy specifically talks about, specifically mentions, these particular hairstyles are such as locks or cornrows are prohibited, that could be considered a no-no. Forcing Black employees to obtain supervisory approval before changing hairstyles, but not imposing the same requirement on others. That could also be considered an issue. So, for instance, if you are asking an employee to straighten their hair, and that's your specific look, or that's the look that you wish for your employee in your work setting, you want to, and you're not imposing the same requirement on others, that's a potential cause for concern. Next slide, please. There are others too. Asking a Jewish employee to cut their payot or shave their beard. Telling a 60-year-old employee with gray hair to color their hair, or telling them, well, you're going to lose your job if you don't. And then ordering a male server to cut his ponytail while not imposing a similar policy on female servers. These are kind of examples of where you could be, what hair discrimination could look like. So what do you do? How do you kind of create that balance? And next slide, please. One of the things you want to do is just, take another quick look at your dress code and grooming policies. Just make sure that they do not contain specific prohibitions that discriminate against a particular race group. And also, look to see if your policies specifically highlight hairstyles as associated with race. Sometimes I've seen policies that say examples of specific hairstyles that are not allowed in the workplace are twists or braids or dreadlocks. You want to include language that is a little more kind of generic in nature, and would be happy to take a look at whatever those provisions are. Employers should consider adding clarifying language to their current grooming policies, specifically in instances where employers require a business-like or professional appearance. Well, what does that mean? What does professional mean to you? As always, in these kinds of areas, we have implicit bias. They're usually not verbalized, but we do have that. And it's always best to kind of talk about that with your human resources professionals, as well as your supervisors. So you kind of can be aware of, the legislative developments in this area, as well as your organization's policies, so that your supervisors and your HR professionals can kind of navigate through those kind of issues. Well, that's pretty much it in a nutshell.
Nilla, that was fantastic. Thank you again for presenting. And with that, we will move on to our next topic. Jane Sovereign is an attorney in our New York City office, and Jane focuses primarily on higher education. Jane is going to provide us with an update on a recent case that was decided that may have implications for many of you. So Jane, please take it away.
Thank you. So I'm going to be talking today about student vaccine mandates in the context of a very recent decision, and I hope bring some takeaways to higher education institutions on this topic. Certainly, we're getting many questions from clients about vaccine mandates, exemptions, mask requirements, all sorts of things. So this case, I think, will be of interest. This decision in relating to Indiana University is the first case to decide a challenge to a student COVID vaccine mandate. The case that was brought by current and prospective students at Indiana University came up in the context of a preliminary injunction request. In other words, the students were seeking immediate action by the judge to enjoin or to prohibit the university from putting into place its student vaccine mandate. And the judge upheld Indiana University's mandate in a very lengthy decision that was issued late Sunday night. And the information is on the slide here, Clausen versus Trustees of Indiana University, and a link to the decision. Next slide, please. Thank you. So the requirement that Indiana University had encompassed students, faculty, and staff. The challenge was only to the student mandate, so that's all that I'll be discussing here. But all individuals were required to be vaccinated in order to be able to return in person to the campus for the fall semester 2021. There is an online option available for students as well. The mandate only extends for the fall semester of 2021 at this point. There were religious exemptions and medical exemptions and deferrals in the case of short-term medical issues that have been already granted and that were provided for under the policy. Those with exemptions, those students on campus would be subject to masking, to increased COVID testing and social distancing requirements, as well as quarantine if they are exposed to COVID, and return home or quarantine if there's a serious COVID outbreak. If a student is not either vaccinated or exempt, the student won't be permitted to come to campus, and their email and university accounts will be suspended or deactivated. Next slide. There were a couple of key factors in this decision that may not necessarily apply to all institutions. Although Indiana state law, like many state laws, requires public university students to be vaccinated for a host of disease, similar, not identical to New York, but similar, and that those requirements in law have been around for decades. Additionally, in Indiana, state law provides very broad powers for the university trustees, including to be able to set standards for admission that are in the best interests of the educational institution, and to have broad power to act against conduct that could pose a serious threat to a person in the academic community. So that was sort of one piece of the decision in this case. Next slide, please. The student plaintiffs, the 8 students who brought the case, were represented by a well-known attorney who brings cases frequently on conservative issues, working with an anti-vaccination group that funded the litigation as it is funding a number of other litigations. 6 of the 8 students had already been granted exemptions, either religious or medical, by Indiana University. In addition to their constitutional challenge, also challenged the challenge to the mandate. They also challenged the masking and testing mandates as violating their rights to bodily integrity, religious freedom, and other grounds, which I think I'll talk more about that because I know that campuses have questions about masking and testing mandates for non-vaccinated individuals, or including those with exemptions on their campuses. The students also challenged the emergency use authorization, which we've seen in other employment litigation contexts. The case, to a surprising degree, the decision really reflected that between the university and the students, there was a real battle over the science, that the students front on challenged some of what the university was saying about risk, about the risk of the vaccine, the risk of what individuals getting COVID would mean. So a very interesting challenge and an interesting decision. Next slide, please. Some of the persuasive arguments to the court, I think, are interesting to look at because they may be helpful either on an appeal or in future decisions. The students and their attorney have already indicated that they will be appealing the decision as fast as possible to the 7th Circuit, Court of Appeals and to the Supreme Court if necessary, even stating the attorney for the students stated that he hoped that the case would be fully decided within a couple of weeks, even at the Supreme Court level. That may be a little ambitious, but in fact, this may go quickly on appeal, and we'll see how soon there may be a decision on this. Some of the factors that were important to the judge included a history of public health protections in this country. There's a case that the Supreme Court held in 1905 in the Jacobson case, upholding mandatory smallpox vaccinations, and the judge found that case to be appropriate here and good law. There was also a very close look in the decision about the robust nature of the emergency use authorization and the level of review that was done before that authorization. Particularly interesting to me, because I was unaware of this, that the EUA has been used in a number of previous public health emergencies in this country: anthrax, swine flu, MERS, MRSA, Ebola, and Zika, as well as COVID-19. And the judge seemed to find that important and persuasive. Additionally, the history of widespread universal in the United States vaccination laws for school children before starting school. All 50 states and the District of Columbia have such laws. In other words, that vaccinations are they are not new. This is not a new issue, and that these issues have been around for some time and have been universally accepted as appropriate in many contexts. Interestingly, also, the case is recent enough and being decided on a preliminary injunction basis. There was a huge record apparently in the case, but the court decided it very, very quickly, reading a ton of information. And the case is recent enough that it includes discussion of the Delta variant and the currently rising case numbers, which I think may be even more important by the time the case is on appeal, noting that that this sort of feeling that among the plaintiffs in this case that COVID is over and done with, circumstances seem to be changing. And as we see, and I suspect Katie may talk about, there's certainly momentum in some quarters for reimposing indoor mask mandates. So I think that timing may help this case potentially on appeal. Next slide, please. In terms of takeaways for institutions of higher education, I have to say, we lawyers are always terrible about saying it depends, we have a caveat, but truly in this case, I want to be very clear. This is a district court decision on a preliminary injunction motion that we know will be appealed and is likely to go to the Supreme Court. So clearly, this is not the last word on student vaccine mandates. However, I think it's important to say the decision is very well reasoned, very thorough. It closely considers the facts of the 8 plaintiffs, the law, the science, the public health background. All of that, I think, may make it a good candidate for this decision to be successful on appeal. The 2 other pieces that I think are helpful takeaways in institutions' actual process and also messaging is the judge was very certain on the points that universities are unique environments. They're not like other environments necessarily of businesses or religious services or others. They require, especially in the residential context, for students, faculty, and staff to be in extremely close contact. And universities are different. Additionally, the judge held, really in terms of the battle of the science, that although students in many cases, particularly residential institutions, are primarily young people, although not exclusively young people, but that he took into account strongly that students, even young students, are not the only ones harmed by refusing vaccinations. And I think those are important parts of both the considerations and the messaging for institutions. Next slide, please. There were some process takeaways here, both in the not sure that everybody can do exactly what Indiana did, but also some general principles. IU was extraordinary in its consideration of how to reopen campus fully in person. Their review was extensively science-driven. They had a committee composed of medical professionals that worked for months on this. They made recommendations to have the vaccine mandate along with other recommendations. Their faculty and staff councils and their graduate and professional student government voted and endorsed those recommendations. The trustees adopted them. I think what you can translate this to, because very few of the institutions that are on this call would be able to do this kind of review and process. But I think the basic point is really the critical one. Institutional consideration, process, and buy-in is helpful in supporting these decisions, that this is not capricious, it's not whimsical, it's not the will of one person who woke up one morning and decided this was a good thing. Additionally, I think having as much consultation as possible with your medical and scientific advisors is also critical and bolsters your process, and I think can be helpful if and when there are challenges. Next slide, please. The implementation also, I think, provides some helpful lessons for institutions. At IU, the judge noted that all of the medical exemption requests are reviewed and considered by a medical team. Again, not something that's reasonable or obvious for every institution, particularly smaller institutions, but having medical folks that you can consult with, I think, could be helpful on medical exemption requests. The judge also noted with approval that religious exemptions were essentially granted upon request. There was not really scrutiny, so long as they were saying the right things, that it was against their religion or they had a sincere religious belief. I would note this is not reflected in the decision, but in terms of process, there has been some discussion. I know some of you have had. Some institutions are using committees to consider religious requests for religious exemptions, which I think some of us here think can be helpful. Some of those committees I've seen include campus clergy people, which I think can also be helpful in terms of process and implementation. IU also determined that the testing that it would require of individuals with exemptions that they would use a saliva test rather than a nasal swab, given that it was, although slightly less accurate, much less physically invasive. That was also commented on approvingly by the judge. Interestingly, the judge, who was a Trump appointee, concluded essentially that masking and testing requirements were really trivial inconveniences, not intrusions on rights, constitutional rights. He also noted that when you have both medical and religious exemptions, you're applying masking and testing rules in a neutral way, which was important. Finally, he made the point, the student plaintiffs expressed concern that masking would be what they called a scarlet letter for the unvaccinated. And I was amused that the judge put in a footnote into the decision explaining what the scarlet letter was. But the judge noted that vaccinated individuals may also choose to mask, going back again to the issue about the Delta variant and some of the movement towards potential greater masking or masking mandates, especially indoors, that this point may become more powerful as this case goes through appeal and potentially a path to the Supreme Court. So I think that's pretty much it. Kathy, is there one more slide as well, or is this it?
I think that's it, Jane.
I think that's it. So that's what I have. Adam,
Thank you.
Take it back to you.
Yeah, no, thank you very much. I appreciate it. Before we get to Katie, I would just point out that this Indiana case is the latest in a line of courts who are rejecting challenges to mandatory vaccination requirements. We had the hospital in Houston, the Houston area, the employees who challenged that vaccine mandate, that was rejected at a very early stage in litigation, but rejected by a judge. Now we have Indiana's vaccine mandate being rejected. So we're seeing this progression of courts upholding vaccine mandates and rejecting in particular the emergency use authorization challenge, which is what we anticipated seeing the most. So thank you, Jane, really appreciate it. All right, last but not least is Katie to provide her weekly update in Albany.
All right, here we go. As always, we have plenty to talk about, so let's get it started. Looking at new reported cases, we have seen over the past 14 days a 174% increase in New York State of COVID-19 cases. Still, the caseload is low. You look at that compared to where we've been, but the rise is concerning. It's especially concerning across the country when you are looking at the vaccination rate. Across the country, the rate of vaccinations for people who are fully vaccinated of all ages is 49%. That's not where we need to be in order to continue to live our lives, with some semblance of normalcy. I wanted to include this as well because this map shows you where cases have been popping up in New York State, especially over the past 14 days. In the capital region alone, caseloads have doubled 5 times over the past 14 days. So it's 5 times more. It's really a confusing amount, but it's a big increase. New York City, you're seeing a large increase. And all of these increases tend to be happening for unvaccinated people. But one thing that's worth noting is that vaccinated people can still catch COVID, can still be asymptomatic and carry it on. So looking at, the progress that New Yorkers are making, yes, we've gone up a percentage point a week, basically in all of these categories for the past 8 weeks. But we're still not at 70% of all of 18 and older people fully vaccinated. Remember, that was supposed to be our criteria for removing all of the COVID restrictions, but we just skipped ahead to say that it was 70% with 1 dose. Looking at all New Yorkers, we're at 56% are fully vaccinated. Again, much better than the national rate, which is at 49%, but still not at the place where we would be for herd immunity. And so what is this causing? Los Angeles is the first major city to announce that they are re-implementing their mask mandate for all indoor, everybody indoors. So anything that you do indoors, you have to wear a mask in Los Angeles County. Part of the reason for that is because this is off the CDC website. It says that a small percentage of people who are fully vaccinated against COVID-19 will still develop the COVID-19 illness. Part of the issue here is that we don't know what happens. If you're fully vaccinated, you can still get the virus and you may not even know it. Again, you may be an asymptomatic carrier and you are spreading it. We don't really know what happens. And based on these increases, it does appear that unvaccinated people, and if you're looking at what's happening at the Olympics, fully vaccinated people are testing positive for COVID left and right at the Olympics. We've had numerous members of the Team USA test positive for COVID, and now they're out, even though they're fully vaccinated. They may not even be showing symptoms. People complaining about head colds recently. I've seen quite a few people that are, on my social media complaining about, oh, I've got a cold again. That might not be a cold. You just might be fully vaccinated and might not know that it's COVID. Throughout this process, as we've seen vaccinations increase, we've seen tests decrease. So the sample size that we're receiving of people who may or may not have COVID is much smaller than it used to be. So that is worth remembering. It may be worthwhile to really to consider masks again. At some point, this question may occur. When do you as a workplace potentially want to reinstate masks for everybody? I know that's not something that anybody really wants to do, but if we have concerns about safety, then that may be a question that you'll have to be considering over the next few months, especially when we get closer to the winter. In terms of what do we think New York will do, it is doubtful at this point that New York will issue a mask mandate statewide. Why is that doubtful? Well, the governor ended the state of emergency that existed. And remember, the governor had issued the mask mandate using that special emergency power that he was granted in 2020. That emergency power was curtailed in 2021. And so whenever a state of emergency is declared now, the governor doesn't necessarily have the power to issue a mandate or directive. They have the power to change or modify the existing statutory framework that we all live in, but not necessarily the power to issue another mandate. But cities and counties would have more of that power to do so. Yesterday, Mayor Bill de Blasio of New York City, said, we're not doing that. We're going to focus on vaccination and increasing vaccination. But with the crunch that school is starting after Labor Day, we're going to be having, kids who are not vaccinated going back to school. There's really a lot of pressure right now to get as many people vaccinated as possible so that kids can go back to school and have school rather than just have remote learning for another year. So it's really becoming, we're seeing a lot of things coming to a head right now that, maybe we all expected that the summer was just going to be chill for the whole thing, but it's not looking like it's going to be just chill. But in good news, we received news that Canada will be opening its border for fully vaccinated Americans beginning on August 9th. Now, the United States hasn't announced their policy yet about what they're going to do with Canadians. Part of the issue here is that Canada has authorized the AstraZeneca vaccine, but the US doesn't recognize that as somebody who's fully vaccinated. But whether or not the US opens it up to just fully vaccinated Canadians or every Canadian, it does appear that as though the pressure is really building up on the president to reopen the border fully, especially with this announcement from the Prime Minister of Canada. But again, we'll see. Tomorrow is the date. Well, today is technically the date that the agreement would expire. We're all anticipating that the president will, re-up it for at least a few more days. But this is kind of a wait and see thing. I'm sure we'll know more by next week. And with that, Adam, I am done.
Katie, thank you so much. And thank you to everyone for joining us this afternoon. I would encourage you all to submit questions. Again, we will do FAQs if we have time. I was scheduled, as you can see, to do those today, but we ran out of time. Either Andy or I will get to those in the next couple of weeks. So please submit your questions and we'll do our best to answer them. Thank you again, and we will see you next week.